Members, not members of this committee, and members of the public. Welcome to this evening's meeting of the Local Plan Advisory Panel. We have one apology from Councillor Woodruss. I believe Councillor Elliott is substituting for him. Part one is the public business, and then part two is exempt business. The item for public business is the minutes of the last meeting held on the 2nd of September. I've been asked to read out a statement because I believe there is some concern about the particular issue of the petition that's been presented in response to the Reg 19 consultation. So before I call on members to approve the minutes, we've had a query raised with us regarding the use of language when it comes to the representations made by, quote, Stop the New Town, unquote, as I understand it. Stop the New Town consider that they have not submitted a petition, but instead have submitted 2,370 individual submissions supporting a shared representation. From the council's perspective, a submission was made supported by spreadsheets demonstrating that 2,370 people had also supported it. That is a very significant number of people, and of course that would be dealt with properly. Whilst I appreciate Stop the New Town disagreeing with my position from an English language perspective, I think it perfectly reasonable for us to refer to this as a petition. As such, I do not propose to make any amendments to the minutes, but I wanted to put on record the concern raised with us and hopefully clarify that when we refer to a petition, Stop the New Town considers this to be individual submissions supporting a shared representation. It might be helpful if I provide this statement to Cameron, our committee officer, not Cameron tonight, it's Ella. That's changed since this was prepared, so that it can summarise this when writing the minutes for the next meeting. I believe, gentlemen here, are you from? You are the chairman. Okay. So what I'm going to do is ask our head of service also to explain how representations are treated. Hang on. I'm going to ask Tess to do this and then I will take any questions, because I think this is quite important, because we need to explain the Reg 19 process and also advice from the planning inspector. So then I will take any questions, and if the chairman wishes to ask a question, I'll take you as well.
Thank you, Chair. Thank you. Just waiting for the mic to come live. Thank you. So the position with regards to this representation, there is some guidance from the Planning Inspectorate, which is incredibly helpful, which basically encourages groups to submit a single representation if their comment or their views are shared by a large number of people. And this is really for sort of practical, logistical reasons. So what the inspectorate have asked for is, where there's a lot of individuals sharing a view, if they can possibly submit one representation, then explain who that's on behalf of. So in this case, I believe the group Stop the New Town very, very kindly followed that advice from the Planning Inspectorate and did just that, submitted a representation, and then it also explained by way of spreadsheet all of the names and addresses of those that support that particular representation. And that was the number that the chair has given, the 2,370 people. So high number of people. So at the last advisory panel, we referred to this as a petition. It didn't use that name itself. It came in as a representation on behalf of those people. In terms of the Planning Inspectorate, what will happen if the council decides to submit the local plan for examination, all of the representations which have been made under Regulation 19 are effectively bundled up and sent to the inspectorate. And it forms a really important part of their examination of the local plan. one of the first things the inspector will look at is all of those representations and start to form a view as to the kind of issues that this local plan needs to be examined on. So for the planning inspector's point of view, they will be sent all of those representations and they will understand the number of people supporting each representation, and that will give them a useful indication of the strength of feeling locally. So that as officers, that's essentially our job, is to prepare all of that paperwork for the inspector. What we also do is prepare a Regulation 22 consultation statement that summarises all of the consultation responses, and again will explain how those responses have come in. So in the case of this particular representation, we will explain that a representation was received and that was supported by 2,370 signatories. Thank you.
Councillor King.
Right. Okay. Well, I'm not happy with what's just been said. I'd like to, first of all, just clarify who's the statement from Simon that you've just read out, please. Who's the statement?
My statement.
Is that your statement?
Yeah.
Or is that the council statement?
No, it's prepared on behalf of the council, but
Okay, you're going to be able to circulate that round on email, are you?
I think we will attach it to the minutes. Yeah,
That's
we can
great,
attach
thank
it
you.
to the minutes.
So in your statement that you've just read out, you said it will be dealt with in the proper way. Can you just explain what you mean by the proper way? What is the proper way?
Just as Tess has explained.
Just as Tess has said, okay. So basically, the reason I'm not speaking for Stop the Newtown, but I have seen correspondence that a member of staff sent them when they queried what the process, what you know about processes in submission, and their understanding was if they did this, that each individual representation would count as a representation, not as a petition. Because obviously, if they wanted to do a petition, all they had to do was do one representation, is to get people to say, "Here, I sign and I agree," instead of getting everyone to make an individual representation, which is in effect what they did. And also, if that was the case, then they could have actually made individual representations, just said to people, here's a template, fill it in and send it in the way that recently Mr. Costa's done lots of multiple FOI requests to Harborough District Council and the County Council on a variety of different matters. They could have done it like that. And therefore, each individual representation would have counted as a representation, not as a petition. Is that what I've just understood you to say? Because it was all done as a bundle. You're basically effectively bundling it up as a petition and saying it's just, well, one submission that's being supported by 2,370 people.
Yeah, but I think
instead
the
of
point,
2,370
the point that's being made, Phil, is that it doesn't
well,
make
it's different.
It doesn't make any difference.
Well, it does. Does that mean
That's your opinion?
Well, hang on. So the further question I've got is, do the 2,370 individuals who you now say it is a petition, but do those 2,370 people who believe they've made an individual submission, albeit it was a copy of one that was given to them, have they still got the rights protected to, if they wanted to seek speaking to the inspector at the examination, or have they lost that right because it's not? They haven't actually made, you're saying they haven't made an individual submission. This is quite an important point, because if they haven't got rights to appear in front of the inspector, that means they've, in effect, the Stop the Newtown appears to have been misadvised or misinformed or misunderstood what they were told. And therefore, that means an awful lot of people are going to find out very soon that they haven't got the right to appear in front of the inspector if they chose that and that's what they wanted to do. So that's the important thing I'm trying to understand.
I'm not privy to the correspondence you're referring to earlier on, so I can't comment on that. I can't ask the officers to comment on that. But I can see clarity on the right to be represented, or if they wish to be heard.
That's the bit I'd like
to
understand.
Okay. Okay. Do you want to comment on that, Tess?
Thank you.
Thank you, Chair. Yes, so we have answered correspondence on to query this point, and we have clarified, having double checked all the regulations. The regulations require that a representation is duly made. Once a representation has been duly made, then effectively that means that the person making that representation qualifies to make further representation verbally at the hearing sessions. So this particular representation was duly made. It was made within the time frame. So each of those 2,370 people, according to my interpretation of the regulations, would qualify to be heard at the examination. I will just qualify that by explaining that the local plan system does not bring an automatic right to be heard. So the fact that a person qualifies to appear at the examination and the hearing sessions does not mean that they will necessarily. And that's because the hearing sessions are really there to ensure that the inspector has everything that they need in order to make a recommendation. So the hearing sessions are very much controlled by the planning inspector, and indeed I've just reread their latest guidance which came out last week just to double check that's indeed the case, and that is the word that the planning inspectorate guidance uses. Those hearing sessions are controlled by the inspector. So the inspector identifies which issues need to be discussed and then prepares agendas and invites for each of the sessions. So if they're having a session on a particular matter, they will understand, the inspector will identify who needs to be there and then issue those appropriate invitations. So what an inspector is likely to do in the case of a representation being made on behalf of a number of people, the inspector is likely to form a view that they only need to hear that particular issue once. So they're likely to invite that group to come together, perhaps 2 or 3 representatives of that group to come together to speak and make that case. Clearly, it wouldn't be practical for that number of people to attend, but certainly that representation, according to my, as I say, according to my interpretation of the regs, has been duly made, so would certainly qualify. But I just don't want to give any sort of false promises that that automatically means that people can attend hearing sessions, because it is ultimately up to the inspector who is invited to which sessions. I hope that's clear.
So thanks for that, Tess. I did understand. That was my understanding, what you just said, actually, that you apply, in effect, to appear at the inspection, examination, and it's down to the inspector to say, well, actually, I want to see you, and you other people I don't really want to see because I've dealt with that issue or whatever, because I can remember that happening in the past. So I do understand that, but obviously, I'm like you, I'm not expecting 2,370 people to request to appear in front of the inspector, but it's whether they have lost. I just wanted to be clear as to whether they had actually individually lost that right, if they so chose they wanted to. I mean, obviously, then most of them I don't expect will. Just brings me to a final, and it's not, I know it's not, but it's just a related point then. So presumably, if a group wanted to apply for, is it still called Section 6? No, are you able to apply for group rights to attend an examination, or is that something different? Have I got that wrong?
Do you think in a Rule 6, that's for an appeal, that's for a Section 78 appeal?
Yeah, okay. So that's only on appeal.
This is different. This is.
I thought groups might be able to do that on. No. Just if we clarify that point.
Yeah,
great, thank you.
Sure. There's not a Rule 6 arrangement in the same way as there is for appeals. And essentially a group would be invited if the inspector wishes to hear from that group. That group would be invited to represent themselves in the normal way.
Yeah.
And the inspector is normally fairly careful about numbers of places around the table. So they might say, for example, it would be enormously helpful if perhaps 2 of you could attend. Yeah.
Thank you.
Did you want to make a comment? Yes, you need to go to a microphone. Is it that one? That one there.
Yeah.
Yeah.
Of course, I'm Dr. Winon. I'm the chairman of STNT, and I'll move the microphone so people can hear me. Thank you, Mr. Chairman, for allowing me to make a short statement. So firstly, this all arose because of a loose language which was utilized at the last meeting, which was described as a petition, which immediately the 2,370 people who signed up to make this joint representation as individuals, if I can put it like this, having prepared a 50-page document, which was well thought through with options, and not just saying that we don't want to build anywhere, but actually here are the issues. There's no investment in infrastructure. Here are the options that we've got. People were very upset, and these 2,370 people came together in 2 weeks. So if we let it roll on, you can imagine how many more people we would have had. So I think it's important as officials and as members exercised in the art, we are not, that we use the right terminology to recognize the work that people did. This was not a small amount of work that people did. You can imagine 50-page document, well researched, written in a planning inspector language by people who are not planning inspector is no small feat to put that together in a month and a half. We also organized an event at the local grammar school where we had more than 300 people who turned up, and we organized that in a week. So it just tells you that it's really important to take that into account. So what I would like to have is that we don't use that petition language. We, on the record today, and I'm grateful to the first statement you've given, that it's really 2,370 individual submissions facilitated by STNT, supporting a shared representation. And the important thing here is that we owe it to the public and to people who are listening to us online that we are transparent. And if it looks like we're not transparent, then immediately we have people being very upset. And I do this as an activity that I do in the evening over the weekend, because I believe that it's important to inform the local community. Just to be very clear, we're not a political party. We're not a bunch of NIMBYs nor bananas. Bananas, for those who don't know what it is built absolutely nothing anywhere, never at all. What we do want to have is an engagement where we understand that the infrastructure and everything else is put in place. And that's what led us to actually write this 50-odd page document. We also have made a submission to ODB in Wixton. We recently, last week, went to see the TRIACS presentation for the Garden Village. So it's really about making sure that that is well understood and the transparency is maintained. Thank you.
Okay, thanks very much for your statement. I believe you've put something in writing that will be replied to in due course, and will obviously give further clarity.
One thing that I would like to say is I would like to thank John Richardson and David Atkinson. I'm sure that Tess, you've also been participating in that effort for the clarification and indeed making sure that we actually had the confirmation in writing that people hadn't lost their rights, because that's what they thought. I also did think the case, so thank you for that. But I would like to make sure that on record, we don't use that petition thing. It is not helpful for the general public. Thank you.
Okay. Anything you need to add, Tess?
Thank you. Only to thank you for your efforts in compiling that response and that number of people. Thank you.
Thank you. Right.
We'll move on. I haven't taken any declarations of members' interests, if there are any. No. Right. So we do now need to approve the minutes.
Obviously, Chairman, the fact we're county councillors, so do we have to declare that?
We haven't been.
Well, let's.
We ought to, I think,
Right.
for the record. Given the county is a consultee to the
I don't think we have in the past on this advisory panel.
Okay. Well, if someone wants
We'll
to
get a
advice,
chance for
yeah, I think it would be best to get advice checked on that, Chair.
Okay.
Thank you.
Yeah, this isn't decision making, you see. But then you're going to ask why it says declarations. But yeah, fair comment. Okay. Right. So if we're all happy with the minutes, I'll sign those.
Queries
On the minutes.
Yes.
Yeah. Okay.
Do you want to take them before
Yes.
you approve them?
Yes.
Okay. We've dealt with the main one, so that's fine. But just on paragraph G, no, sorry, paragraph A. The last part of that, obviously we had a discussion about statement of community involvement. I know David's not here this evening, but he did say that he had made the decision under delegated authority. Now, I thought he actually said he would let us have, he would let us know when that delegated authority, what that was, when it was actually made. And I've not received anything about that, and it's not in the minutes. So I'd just be grateful if, on the record now, can request for a copy of when that delegated authority is actually related to what decision.
I don't know if it's been done. You know, it's been done. So the issue is in relation to H. David Atkinson explained on the statement of community involvement, he was going to approve that under his delegated powers. And Councillor King's asking if that's been done.
No, he said he would, it was done under state. He said the review of the statement of community involvement was done because he had delegated authority. What I'm asking is, when was that delegated authority given? What
I don't know.
point?
I
So-
suspect it's been there in the council for a long time.
Okay, so if we've got, if David's relying on a delegation, I'd like to, I think it's beholden to produce that delegated authority decision of when that was actually given. Otherwise, how does he know he's got a delegated authority decision to make on it? If he can't produce it, he doesn't know he's got it, does he?
Okay. So as you know, all record of delegated decisions are published on the website.
Yes, I know that, and David would have had to publish a statement to say he was making this decision and what under delegation, but I'm just asking, saving me looking it through because it's not terribly well indexed, and me having to try and find it, if it's possible, for the team to produce that.
Sorry, I'm not clear. Are you asking for the original decision to delegate this
But
to
in the,
officers, or are you asking for when he took the decision on this particular statement?
okay, so let's just work this through. So in that bottom paragraph, it says, David Atkinson stated in the current, it was appropriate for any update statement to be made by him under his delegated authority. So David says he's got delegated authority. Okay, so when was that delegated authority to make modifications to the statement of community involvement made? When was the decision? When was the power vested in him?
Well, I suspect it was done in a constitution
No,
many moons ago.
no, that's not a
You're telling
delegated
us that's not correct.
I don't think it is. Well, if it is, let's be clear. If it's under the Constitution, then that's fine. There'll be a constitutional reference point, which clearly someone can give us. If it was a delegated decision based on when the statement of community involvement was made previously, which is a long time ago, okay, then I'd like to know which decision, if the cabinet and council made a decision to adopt the statement of community involvement and said we'll delegate authority to the director to make minor modifications, well, when was that minor modification delegation given? If it's a long time ago, that delegation surely has a sunset. It may have run out. So I'm just trying to understand when this was actually given. If David has then made a decision, and under the delegation, then he's required to make a statement.
But that's the thing. I think you're dancing on the head of a pin here. What difference does it make?
Well, it's proper process in due governance. That's what it is.
But what is the outcome? What's
Well, we need to demonstrate.
have you got a problem with the statement as worded, or is it the process by which
I want to know we're following the right process.
It's about the process, not the content of the statement?
Well, I want to know we've actually followed the right process. Yeah.
Yeah, so it's about process.
That's what I'm asking, and I'm not.
Okay.
A statement's been made at the last meeting.
Well,
I'm trying to understand.
David's not here, but
No, I appreciate that.
I
That's why I'm not.
will discuss that issue with him. Okay.
Great. Okay. Thank you.
Right. Are there any other issues on the minutes? Councillor Page.
That's me. On that, I also asked, and it was never answered, whether the community statement, the community involvement statement can also, it's valid under the process if there any alterations are done under delegated power. because if I recall, the first time we had to consult on that. So it was a matter of process and that wasn't answered. And just another point, just for information, under 2, in the 3rd paragraph, it states, up to date, no postcodes of affected properties have been received for this cross-checking to take place. Yes, I did. I can't find them, but I sent several emails of about 3 or 4 people. And of course, I gave my own. So, you know, somewhere there. And
Yeah,
some
but
from
look,
Oliver.
this is about the accuracy of the minutes. This is about the
Yes, but I did say that at the last time. I did say that I sent mine and that I sent some.
what you want that recorded in the minutes.
Yes, that we did send some. I don't know where they've gone and I can't find them now on the thousands of emails, but some have been sent from Ollithorpe and I think some from Lutterworth as well, weren't they?
Well, Ella's taking all this down, so I can't comment on that particular issue, but if that's what you're saying, it will be recorded in the minutes. So can we, I'm going to propose the minutes. Can I have a second, Councillor Borrell? All those in favour? Thank you. Right, okay. Right, they're approved. So, taking us nearly 30 minutes to do the minutes. We can move to the next part 2, which is exempt business. So I need to read that the following item is suggested to be dealt with under the above legislation. To comply with the Act, the following resolution needs to be passed, that the public and press be excluded for the remainder of the meeting on the grounds that the matters yet to be discussed involve the likely disclosure of exempt information as defined in paragraph 3 of Part 1 of Schedule 12A to the Local Government Act 1972. All those in favour?
What you're actually going into exempt session for, is this to consider item 6, 7 and 8 on the minutes? Because that says it's a summary of items we've discussed. I'm a bit confused by the agenda because it says draft public minutes, then it says section 100A, then it says draft non-public minutes of the last meeting. Well, there's nothing in section 6, 7 and 8 of the minutes before me that I would consider to be A, commercially sensitive, or B, require you to go into exempt session. If you're talking about going into exempt session for the local development plan, and obviously the presentation, well, obviously as we have got no idea what's in this presentation, it's a bit hard to know whether we need to go into exempt session or not. But if I can just say feedback on the last meeting, we went into exempt session, and I have to be honest, most of the content of that meeting I don't consider was actually
That's your opinion.
Well, it is, and I don't see why we had to go.
It's a matter for the committee whether they wish to go into exempt session.
But it came out in the briefing and it was circulated. We went into exempt session.
So the briefing was also confidential, Councillor Page, and I read out a statement at the beginning of that online briefing explaining that.
Okay,
so there was no difference.
So you're moving to a vote then on what you've read out anyway. So, but I'm just trying to clarify what you were going into exempt session for.
We're going into exempt session for item 5 and item 6 because those matters under item 5 were dealt with as exempt. Therefore, it wouldn't be correct not to take those minutes.
I find that somewhat surprising. I really do. There's nothing I'm reading here that would
during the preparation of the last local plan, Councillor King, I don't remember any questions or challenges from yourself regarding whether or not we should go into exempt. It was accepted that the information being provided to members at that point in time needed to be confidential. My key motivation in that is mainly around developers, agents, and all the sorts of other people that are watching us doing this process, and that we don't reveal what we're doing until we are happy that we have come to conclusions. I mean, there's still a lot of work going on. So I think we would be exposing ourselves quite considerably by not going into exempt session. But, you know, you'll need to judge that when you hear the officer's presentation. I think that's, you know, you can't do it retrospectively. We have to do it first, don't we? So I'm going to take a vote on going into exempt so we can proceed. You in favour, Councillor Gare? Yep. Okay. Sorry. Can I get a proposer first for going into Councillor Burrell? Councillor Gare is seconding. Can we just show the hand, please? Thank you. Right, so we're now going into.
Can we record abstention or vote against?
Are you? Okay, you want to vote against? Right. Abstentions?
We're
I
going
don't think we record abstentions.
Well, I want a recording that we didn't support it, or we abstained.
You abstain?
Yeah.
Okay.
Because
Yeah, we don't normally record abstentions. Right. So can we turn the